I'm Janelle Matuszak, and you're here for Workers' Comp Basics for Beginners Part 2 webinar. If you missed the Part 1 we did earlier this year, it's available on YouTube. If you just type in Bugby and Conkle, Workers' Comp Basics for Beginners, it'll come up. Today, we're going to concentrate a lot on temporary total and issues surrounding temporary total, including voluntary abandonment, and then I'm going to talk a little bit about vocational rehabilitation if I have time. If you have questions, temporary total. I'm going to start with the definition. Temporary total is payable when your claimant's off work due to the allowed conditions in the claim. It's an inability to perform job at the time of the injury. So an inability to return to the former position of employment will get the claimant temporary total payments if they're off work. Has to be due to an injury-related impairment with a reasonable expectation of improvement. That means that it's temporary, they're getting better. If it was a permanent injury, that would be maybe a different kind of compensation, but for temporary total, it has to be something with a reasonable expectation of improvement. Now, how much does the claimant get? The compensation rates for each state of injury cap out. So if your claimant's injured in 2018, they can't get more than $932 a week, but it's calculated at 66 2/3% of their claimant's average weekly wage. So they take what they made for the year before the injury, 52 weeks, they divide it by 52 and come up with their average weekly wage. And then the claimant gets 66 2/3% of that, which is the reason why they only get 66 2/3% is it's not taxable. So it can be very costly for a company for a claimant to be off on temporary total. The state max in 2018 is $932. I already said that actually. Okay, like I said, it's payable when the claimant's temporarily disabled. Have to be unable to return to their former position of employment due to the allowed conditions in the claim. This is important because it's not that the person can't work at all. They don't have to be so injured that they can't work at all. It just has to be that they can't return to what they were doing when they were injured. So if you have a labor-intensive job where the claimant has to be able to lift 50 pounds and their doctor says they can lift 25, not 50, and you don't have a job within those restrictions, they'll receive temporary total. Okay, the allowed conditions must be independently disabling. That means if your claimant has, or your injured worker has more than one thing wrong with them, the conditions related to the claim, their injury at work, have to independently disable them. So your claimant hurts their back at work, but they also happen to have a knee problem. You can't have a situation where both combined render them disabled. The back alone would have to be enough to disable them, and a doctor has to certify that if it were only the back, that would be enough to disable them in order for them to be eligible to receive temporary total. As I said before, disability must be temporary, so there has to be room for improvement. There is no limitation on how much temporary total a claimant can get. I've seen claims where they can get up to 7, 8 years. It's just as long as the conditions continue to improve, or there's a reasonable expectation of improvement, they can continue to receive temporary total. There's no time out or time limit to that. So how do you get the claimants off of temporary total? There's 4 ways. The first is they return to work. So you can't receive temporary total while you're working, which should seem pretty obvious. The issue that comes up sometimes is the claimant has a full-time position where they're injured, and then maybe they have a part-time position somewhere else. They have 2 jobs. They can't work either job while they're on temporary total. So if your claimant returns to any kind of work at all, temporary total should be cut off. Second way to terminate temporary total is the treating physician makes a statement that they're capable of returning to their former position. So the doctor thinks they're healed enough to return to work. Claimant disagrees and does not come back to work. The company can stop paying temporary total, or the Bureau stops paying temporary total, depending on whether the company is self-insured or state-funded. Another way is claimant has reached maximum medical improvement, which I'll talk about more in a couple of slides. But basically that means they've reached a treatment plateau. They're not getting any better. So therefore their disability is no longer temporary. They may be entitled to another kind of compensation, but temporary total will be cut off. We'll talk about the mechanics of that in a couple of slides. The fourth way is claimant's treating physician has given him restrictions, and claimant's offered work within those restrictions. So I kind of touched on this a couple minutes ago. If your claimant has a job where they have to be able to lift 50 pounds, they hurt their back at work, and the doctor gives them restrictions and says he can lift 20 pounds, not 50, then he can't return to his former position of employment. If the company has no job for him, he's entitled to temporary total. But if the company offers him a job within those restrictions, obviously if he comes back to work working light duty, he's not entitled to temporary total. But if he refuses that light duty job offer, he's also not entitled to temporary total. I'll break that down a little more in the next slide. Okay, so in order to get a claimant off of temporary total based on a light duty job offer, it has to be a good faith job offer, which means a proposal made in good faith of suitable employment within a reasonable proximity of the injured worker's residence. So if your company is in Toledo and your claimant works in Toledo, you can't offer them a job in Columbus because that's not within reasonable proximity of their residence. You probably could offer them a job in Bowling Green, something like that, as long as it's in good faith. Now, the job offer has to be in writing based on restrictions given by the treating physician. They can't be restrictions given by the company doctor or an independent medical examiner. It has to be the treating physician, and it has to be in writing. So it needs to be more than just a phone call to the claimant that you have work within the restrictions. And the writing has to be very specific. The Industrial Commission is pretty hard-nosed about this. It has to identify the position and include a pretty detailed description of the duties. We see a lot of these where the job offer just says, here's your restrictions, and we give you a job within those restrictions. That's not enough. You have to say what the restrictions are and clearly state what they will be doing. And then obviously what they're doing has to be within those restrictions. Back to the good faith portion of this. The job offer given cannot be given in order to get the person off of temporary total. What I mean is the intent of the company can't be bad faith. So you can't offer them a job that you know they won't take just so you can try to terminate their temporary total. The guy's some kind of labor position, we're going to offer him some kind of janitorial position or something just because we know he's not going to accept that, and that way we won't have to pay him TT. Now, it's hard for the claimant to prove that that's a bad faith, but it is one of the things, if the hearing officer thinks that you offered them this job just to terminate TT, it will be deemed bad faith, and they'll still get their TT, their temporary total. Okay, I said I'd go back to maximum medical improvement. All right, maximum medical improvement is a treatment plateau at which no fundamental functional or physiological change can be expected within reasonable medical probability in spite of continuing medical or rehabilitative procedures. Okay, so maximum medical improvement just means they're not getting any better. They may not have been cured, they're not getting any better. So your claimant with a bad back is treating and has surgery, and maybe you get them to a treatment plateau where they've improved, but they're never going to be back to where they were. They can never lift those 50 pounds. If you get a finding of maximum medical improvement, that terminates temporary total. And so how does that, there's different ways you can get them at maximum medical improvement. The treating physician can say they're at MMI or maximum medical improvement, and that will automatically terminate temporary total. That's the easy way. And the Medco 14, which is the form the treating physician fills out to continue their payments of temporary total, on the form on the second page, they're asked, to say whether the claimant has reached maximum medical improvement yet and comment on that. So if they check yes, that they've reached maximum medical improvement, then the claimant is no longer eligible for temporary total. What happens more often is the company has to get their own doctor, or the bureau will get a doctor to say they're at maximum medical improvement. The company is entitled to an extent of disability exam every 90 days. So if your claimant has been on temporary total for 90 days, or it's 90 days after the injury, you can get your own exam and ask your own doctor if they've reached maximum medical improvement. So let's say you send your claimant to Dr. Smith and you ask them if the claimant can return to their former position of employment, have they reached maximum medical improvement. The doctor gives you a good report. From there, you can't just automatically stop temporary total, or the bureau doesn't stop temporary total. You have to take it to hearing. So once you have your good report, you can file a motion with the Industrial Commission asking the commission to find that they've reached maximum medical improvement. And the hearing officer will look at the medical evidence and all the other evidence in the file and decide if they've reached maximum medical improvement. If a finding is made of MMI, then then the temporary total is terminated. And it's sort of similar with the good faith job offer. If your claimant has received restrictions from their treating physician, saying they can return to work light duty, and you offer the claimant a job and they refuse to accept it, you can't just terminate temporary total on your own. You have to file a motion with the commission asking for a finding to terminate temporary total because of the refusal of a good faith job offer. So 4 ways are, just to review quickly: claimant can return to work, claimant's doctor can say they return to work, they don't actually do it, which happens a lot. A finding of maximum medical improvement either by claimant's doctor or the Industrial Commission. And the good faith job offer. Claimant receives light duty from their physician, but refuses the good faith job offer by the company. It can be a little confusing because the company doctor or an independent medical examiner can find the claimant is at maximum medical improvement, and the commission will rely on that to terminate TT, but the commission will not rely on restrictions from the independent medical examiner. Those have to be from the treating physician. Important note, maximum medical improvement will terminate temporary total disability compensation, but it will not terminate treatment. So if the commission makes a formal finding that your claimant has reached maximum medical improvement, they're not entitled to temporary total any longer, but they can still treat. We see this a lot with chiropractic treatment or physical therapy, medications a lot. That kind of treatment is just to keep them at a static level. It's a common misconception that an MMI finding will terminate treatment, but it does not. Sometimes helpful, but it doesn't terminate it. Okay, and then a question: can the claimant ever receive temporary total again after an MMI finding? And it would be the same question: can the claimant ever receive temporary total again after returning to work? And the answer is yes, but it's a little bit higher standard. The claimant has to show there's new and changed circumstances in the claim to justify the new period of temporary total. This is usually a surgery or a new condition. So if your claimant's at a static level and then they undergo surgery, that is always going to bring a new period of temporary total because no one can return to work right after the surgery. And you have to go through the whole process again. They had their surgery, they'll have a new period of temporary total, and then you need one of the 4 things again in order to bring them off temporary total. A new condition is very common. A lot of times when the claimant
has lost their benefits and they don't want to go back to work, they'll ask for another condition and they can get a new period of temporary total. So if we take the claimant we talked about who hurt his back,
you finally get the commission to agree that he's at maximum medical improvement. They terminate temporary total. And then the next thing you know, they filed a motion asking for depression to be included in the claim, and they want temporary total associated with that depression. And then you have to go through the whole process again, of getting them to maximum medical improvement as a result of the depression. I should note, too, when we talked about the 90-day exam the company's entitled to, let's say you get your 90-day exam, you have Dr. Smith who says your claimant has reached maximum medical improvement. You take it to hearing, and the hearing officer doesn't agree with you. So if they've not reached maximum medical, temporary total to continue, you can try again 90 days after the last exam. So let's say your exam was January 1, you can get another one around March 1st. I don't think that's exactly 90 days, but around that time, you can try again and keep trying till you get them off the temporary total. Okay, one of the biggest issues for temporary total is voluntary abandonment, and that's what the bulk of this presentation is going to be about. Voluntary abandonment means the claimant has voluntarily or either voluntarily left their employment or their actions have been such that they are deemed to have voluntarily left their employment. And so the reason why they're not getting wages is not because of the allowed conditions in the claim, but it's actually because they don't have a job because of something they did, and so therefore there's no wages to replace. And I'm going to explain that in more detail. It began with this Louisiana Pacific case. You might hear attorneys sometimes refer to voluntary abandonment as a Louisiana Pacific issue. In this case, and is a very familiar fact pattern, this happens a lot, claimant was on temporary total, and the doctor said he could return to work December 17th, and claimant didn't come back to work December 17th, didn't show up or contact the employer until January. And the company had a written policy that 3 failures to report 3 days in a row was ground for termination. So they terminated the claimant, and when the claimant was no longer getting their temporary total checks, they took it to hearing on this issue. The company argued there was a voluntary abandonment, that it was claimant's actions that caused him to lose his job and not be receiving compensation. So the reason why a claimant wasn't getting paid was not because of his work injury. His doctor said he could return to work. It's because he did something that required the company to terminate him, and therefore he wasn't entitled to compensation. In this case, and he found a new doctor, of course, in January who wrote him off work again, so he wanted payment for temporary total. The court found that he had voluntarily abandoned his employment. Although he hadn't quit, what he did resulted in termination, and therefore he wasn't entitled to temporary total. And that began this whole series of case law surrounding voluntary abandonment. So the theory behind this is when a claimant is fired, he's deemed to have voluntarily abandoned his employment and is not entitled to temporary total. Quitting work is also a voluntary abandonment. So in the same scenario, instead of the doctor returning him to work, had the claimant tendered his resignation, on December 17th, he also wouldn't be entitled to temporary total because there's no job to go back to. So it's not the allowed conditions preventing the return to work, but his actions that resulted in the termination. The Industrial Commission does not like these voluntary abandonment arguments a lot, and so they force us to really prove our case before they'll terminate temporary total as a result of a voluntary abandonment. And the reason is that it's suspect when you terminate a claimant who's on temporary total or who has a workers' compensation claim. They want to make sure that they actually violated a rule, and that's why they were fired, not that the employer just wanted to get rid of them so they weren't on the hook for temporary total anymore. So there's a 3-prong test that was developed by this Louisiana Pacific case. And the first part of this is the termination has to result from the violation of a written work rule. So the prohibited conduct has to be known or should have been known to the employee. Has to be identified as a dischargeable offense, and the written work rule has to clearly define the prohibited conduct. So if you don't have any rules in writing, then you don't have a voluntary abandonment. There's a case where a truck driver kept getting DUIs, and he no longer had his CDL, his commercial driver's license. So obviously he couldn't continue his employment as a commercial truck driver. He was terminated, but he still got temporary total because there weren't any written work rules that said you needed to have your commercial driver's license in order to be employed there. So you have to have, even if it's obvious, it has to be in writing. I mean, it's obvious to us that you can't get into a physical fight at work, things like that. But if it's not in writing, it won't result in voluntary abandonment. It has to be in writing as a written work rule, but the rule also has to say that violation of this rule will or can result in discharge or termination. And it has to be clearly defined as much as possible. We see a lot of voluntary abandonment that are attendance issues, points, or like the Louisiana Pacific case where 3 no-call, no-shows resulted in termination. Those are pretty easy to clearly define, but other things like insubordination are a little harder to define. You can't allow for every scenario that would result in termination. Just do the best you can. A lot of times things fall into insubordination. The person has to actually be terminated for the conduct. So something like attendance points, let's say you have a policy where 5 points results in termination, but you don't usually terminate people when they reach 5 points. If you terminate your workers' comp claimant for reaching 5 points at nobody else, that's going to be suspect, and the commission could find that they were actually terminated because of the comp claim, not because of the points. So those are the kind of things they look at. You want to make sure you have written work rules or policies that define all the prohibited conduct and specifically state which conduct will result in discharge or termination. If your work rule says, just a list of things not to do, but never does it say this could result in termination, you're not going to have a voluntary abandonment because the claimant hasn't done something that they know might result in them losing their job. The other thing is the conduct has to be identified to the claimant. They have to know that it's prohibited. So the best way to prove to the Industrial Commission that the claimant knows they did something they weren't supposed to do is to have signed receipts for handbooks. And most companies do that. It's not an absolute requirement. If you can show some other way that they knew about the conduct, then that's good enough. A lot of times we file last chance agreements too. That can be a written work rule. A last chance agreement, as long as it says, and that's simply an agreement with a company, letting them know that the claimant know that their attendance has been bad, and one more no call, no show, and they'll be terminated, that kind of thing. There's a written work rule. They know it could result in termination if it's signed by the claimant. That's enough there. Be careful with this when you update rules. A lot of times a company will have a signed handbook, but it's from 5 years ago. They've updated the rule, and the new rule's in play, but there's no signed acknowledgement. But we can use things like, a lot of companies, when they update, will have a little training session, and everybody will sign in to show that they were there. That's helpful. You can even have somebody else from the company testify that they explained the rule to the claimant, or that they were there when they were training. Signed acknowledgement is really the best thing, but you can do other things to prove they knew about the rule. Okay. So as I said, the work rule has to be in writing. There's a lot of case law dealing with this. This is probably the biggest litigated issue in workers' comp, is what's a voluntary abandonment and what is not. I won't bore you with all of that. I'll just try to give you a summary of what we've learned. So like I said, the rule has to be in writing, even if it's obvious that this could result in termination. If you have no written work rules, you have no voluntary abandonment. And this is a big problem because, like I said before, temporary total can be very costly. If you terminate a claimant and their temporary total is not terminated, they continue to be on temporary total, you have a big problem because there's no incentive for them to come back to work. They don't have a job. So it becomes harder to terminate the temporary total if you can't offer them a job to come back to. Not impossible. They can still reach maximum medical improvement, but it's just tougher. Make sure your rules clearly define the prohibited conduct as much as possible. We talked about notice. You need a signed handbook acknowledgement if possible. Not an absolute requirement, but makes it easier to prove knowledge. And make sure you get acknowledgments for rule changes. Claimant must be on notice that the conduct will result in termination. All right, if you have a voluntary abandonment argument, just mechanically, this is how it usually happens. The claimant will file a motion requesting temporary total. And the company will object to the motion, and then you go to hearing. Before the hearing, the company has to provide claimant and claimant's attorney with everything they intend to rely on. So you want to file a copy of the written work rule with the commission before the hearing. I almost always am going to want somebody from the company at the hearing so they can explain the rule. I find that a lot of attendance policies are very complicated, which can be a problem because if I'm confused, it's easy for the hearing officer to conclude that the claimant was also confused and didn't realize they were breaking the rule. So they didn't have knowledge that that rule would result in termination. But also a big issue is the claimants will often come to a hearing and claim that the attendance was not the real reason they were terminated, it was the workers' comp claim, or even though your records say they were late 10 times in a row, they weren't actually. And so always want to have somebody from the company there to refute what the claimant is saying on these voluntary abandonment issues. Very difficult to win without somebody there. And then a big one is you want to be able to show that the rule is applied to everyone equally, not just the workers' compensation claimant. So when you can, I like to have a company rep say, let's say your claimant was discharged for 3 no-call, no-shows. You can say, I've had 4 people this year discharged for the same issue. No one was given a second chance. Treat everybody the same. That way there can be no dispute that the actual reason for the termination was the violation of this work rule regarding no-call, no-shows, and not anything having to do with the workers' compensation claim. You want to be able to show that the claimant actually violated the rule, which is why you want somebody from the company there to testify. Even though your time clock says they were late, they might come and say that they weren't actually late, there's something wrong with the time clock, or any number of things the claimants will try to say to get past this argument. And the termination has to be based on the violation, not on other things. It must be in good faith. One of the things I see a lot, a couple of things, they're kind of funny. I'll have these voluntary abandonment arguments, and the claimant will often come to the hearing and say they didn't even know they were terminated. And it didn't come up until you filed this motion for temporary total, for voluntary abandonment finding. And the way that happens is the claimant thinks they're off work. This is what they argue. They're off work due to allowed conditions, and that's why they're not coming to work. They didn't realize you even terminated them. So make sure the claimant knows they're terminated, because it's kind of hard to prove that they were terminated for a violation of a written work rule if you didn't inform them that they were terminated. It kind of sounds like you're coming to the hearing deciding they were terminated after the fact. So make sure they know they're terminated. And the second mistake we see a lot is the company sends a letter to the claimant informing them that they're terminated, which is good, and they list the violation of the written work rule as the reason, which is also great, But then they list 3 or 4 other things the claimant did wrong as reasoning, and that's not good for voluntary abandonment. Because then the hearing officer can look outside that violation to other issues of why they were terminated. You need to be able to show that they were terminated for violating the written work rule. So if the letter says they're terminated for their attendance points, but also you have a bad attitude and you didn't have your equipment this day, those kind of things, the hearing officer can say this isn't a voluntary abandonment because there's no written work rule pertaining to these things, and it just muddies it up. So make sure they know they're terminated, but make sure they know they're terminated only for the violation of the written work rule. Don't add extra things when you have a workers' comp claimant, especially. What if the claimant gets a new job? So let's say you have a claimant on temporary, well, let's say they're back to work, but they're terminated for no call, no shows. Claimant then needs a new surgery for his back, and he asks for temporary total. You object. You say, I fired them for the violation of the written work rule for his no call, no shows. You go to hearing. Hearing officer says, no temporary total for the claimant. He violated this written work rule. There's a voluntary abandonment. That doesn't mean that he's never going to be entitled to temporary total again. If the claimant gets a new job, they re-enter the workforce, voluntary abandonment no longer applies. They can get temporary total again. So if they get a new job with a new employer, let's say they need a second surgery, they're obviously disabled again. Even though there's that old voluntary abandonment finding, they can be entitled to temporary total again. This doesn't happen that often, but it does happen. And the theory is now there are wages to replace. The reason your claimant is not getting paid is because of the allowed conditions in the claim, the surgery. If it wasn't for the workers' comp claim, they would be getting paid, even though it's by the second employer. Your temporary total rates remain the same as they were for your company. They don't change because they got a different job. Okay, pre-injury actions result in post-injury termination. This is kind of a highly litigated issue for a little while here, and it's gotten a little simpler. But this gross case involves a guy who worked, I believe it was Kentucky Fried Chicken. If it wasn't Kentucky Fried Chicken, it was something really close. And one of his jobs was to clean the fryer that they fried the chicken in. And he was told several times to do it a certain way for safety reasons, and he just never did it right. And there was a written work rule that said this is how you clean it, and if you don't do it right, you'll be terminated. And so, of course, he did it the wrong way. He was injured because he didn't clean it correctly, and he was unable to return to work because of this injury. In the Ohio Supreme Court, the company argued he had voluntarily abandoned his employment because he cleaned the fryer incorrectly. There was a written work rule prohibiting that. The work rule said it would result in termination. They did terminate him, so they said he wasn't entitled to temporary total. And the court disagreed in a decision that I don't completely understand, I don't agree with. The court said, let me go to the next slide. So if the violation of the rule was the actual cause of the injury, so cleaning the fryer incorrectly was what actually caused his injury, and he's terminated for violating that rule, there's no voluntary abandonment and temporary total is payable, which is kind of huge for the claimant because now they don't have a job to return to. Like I said earlier, it's harder to get them off temporary total if there is no job. And this guy did the wrong thing by cleaning the fryer incorrectly, but he continued to get compensation. There's some follow-up cases. This Cordell, I think, came out in December of 2016. This was litigated for a little while, this scenario. Claimants terminated after testing positive for marijuana after a post-injury drug test. So there was some arguments before Cordell about whether the marijuana was taken before the injury and that's what caused the injury. So does that mean there's no voluntary abandonment, or is there a voluntary abandonment because the drug test came after the injury. And Cordell makes it clear that if there's a pre-injury work rule violation of using marijuana, it does not sever the causal connection between the injury and the loss of wages because he was not intoxicated or impaired at the time of the injury. And the injury results in the discovery of the marijuana use. If you're not following that, it just means if your claimant tests positive for marijuana after a work injury and they're terminated for that, the court does not deem that to be a voluntary abandonment. So the takeaway from that is really that if the rule violation is wrapped up in the work injury or caused the work injury, there's most likely not going to be a voluntary abandonment. We see this all the time with drug cases. And I'm not telling you not to terminate your claimants, just realize that they're probably going to continue to get temporary total, but you have to do what you need to do to run your business. So a claimant who's medically incapable of returning to work as a result of a workplace injury and was terminated after the injury for pre-injury conduct that was discovered as a result of the injury, as a result of the drug test, has not voluntarily abandoned his employment under Cordell. There used to be a lot of litigation about termination while claimants working light duty, and the reason is when you're working light duty, you're not really working your former position of employment. It's actually been a little simplified, so without going into the whole history, all you really need to know is that termination while working light duty is still a voluntary abandonment. So you're working a light duty job as a result of the allowed conditions in your claim. You have 3 no-call, no-shows. That's still a voluntary abandonment, regardless of whether you're working your old job or your new job. You can also, I should say, you can also voluntarily abandon your second job. So the scenario I talked about earlier where claimant was terminated, you get a finding of voluntary abandonment, no TT, no temporary total. They get a second job, let's say they get a second job, second place, but then they need to go off again because of surgery, something like that. I told you they could be re-entitled to temporary total. They can actually voluntarily abandon that job too by being terminated due to a written work rule at the new employer. The problem with that is it's hard for us to prove because we need cooperation of the new employer to give us the work rule and prove that they're actually terminated for the work rule, that kind of thing. So we don't see that very often, but it is a possibility. You can voluntarily abandon your new job. So here's just an example, Adkins versus Industrial Commission. Claimant was terminated when she failed to report for light duty. So this is one of those light duty job offers. She was given restrictions by her treating physician. Company offered her light duty, which she accepted, but then she never showed up. Well, the failure to accept a light duty job offer based on restrictions from your treating physician is enough to terminate temporary total, but it's also a voluntary abandonment if this no call, no show is a written work rule. Still a voluntary abandonment. This Crestview Manor nursing home was a claimant who kept leaving her light duty job offer early in violation of work rules. And in this one, this is one of those where the written work rule wasn't really clearly defined. It was just defined as insubordination. But the court found this was enough for a voluntary abandonment. She must have been told to stay until the end of her shift. There's a work rule that said insubordination could result in termination. And therefore, that was enough for a voluntary abandonment finding. So it's a little confusing, which is why this is one of the most litigated issues in workers' comp in Ohio, and it's evolving all the time. Each case is fact-specific, and you could have the same fact pattern that one hearing officer says this is a voluntary abandonment and another hearing officer says it's not. It really just depends on the specific fact scenario and who you have. So you just want to make sure, like I said, you file all your evidence, your written work rule, your handbook acknowledgement, have somebody from the company at the hearings to argue it. And this is one of those two where it is a voluntary abandonment is a legal argument. this is something you would need an attorney to argue. Okay, another way to leave employment, we talked about a voluntary quit, can be a voluntary abandonment, should be a voluntary abandonment. We talked about a termination, which is a little more complicated. If you meet the certain criteria, that is a voluntary abandonment. But what about voluntary retirement? So temporary total is designed to compensate a claimant for lost earnings during a period of disability while they heal. It's a wage replacement because they can't go to work because of their injuries. So if your claimant leaves work for reasons unrelated to the injury, they're not entitled to temporary total. They quit because they don't like the hours, they're moving to Florida, something like that. They can't get temporary total. But if they retire, you have to look at whether they retired due to the allowed conditions or if it was unrelated to the allowed conditions. A retirement is a voluntary abandonment, which means they're not entitled to temporary total unless the retirement was causally related to the industrial injury. So back to the claimant who hurt his back, can no longer lift 50 pounds. Let's say he has permanent restrictions. He can only work lifting up to 20 pounds. So he decides he's going to retire. He retired 10 years earlier or 5 years earlier, whatever it is, because of this workers' comp claim. He had intended to continue working, but now he's retired because of the claim. That's a voluntary, I'm sorry, that's not a voluntary abandonment. If they retire because they have to because of the claim, not a voluntary abandonment. They're still going to get temporary total after they retire, which makes a lot of companies really upset because sometimes they're getting their pension or maybe disability retirement on top of the temporary total. So you want to try to prove, obviously, that your claimant retired for reasons unrelated to the claim. And one of the ways you can do that is argue retirements based on years of service and not disability. Obviously, the older your claimant is, the easier it's going to be to argue that they retired because they've hit retirement age than they retired because of the claim. Another important factor is same claimant, can't lift 50 pounds, he can lift 20. He retires, he says it's due to allowed conditions. But if he's made no attempt to find other employment, then you have a strong argument that he has abandoned work entirely and he's truly retired, not because of the allowed conditions. Okay, so what can a company do to protect themselves? Because like I said, this can be very costly if your claimant's collecting temporary total after retirement as well as other benefits. If you can, put in the retirement agreement that retirement is not related to the claim. If it's applicable, that the claimant's no longer treating for the workers' compensation claim. This is something that's helpful too. If your claimant has retired and they say it's due to allowed conditions, but they haven't treated with a doctor in 2 years, then it's going to be a harder argument for them to make that they had to retire if they're no longer treating. It's not impossible because sometimes there's no more treatment for them, they still can't lift because of the allowed conditions. But also, if you can put in the paperwork that the claimant does not intend to return to any kind of employment following retirement, it's also helpful to show that they retired for reasons other than the claim. We had a case once where the company did these things, but then the claimant wrote on the side of the retirement page in his own handwriting that he's actually retiring because of his bad back or whatever the condition was, I can't remember. And the commission took that into consideration to determine that he did retire due to the claim. So don't let them write on the agreement. And don't assume a regular retirement as opposed to a disability retirement, if your company offers both, will automatically show that they did not retire due to the allowed conditions. I've had claimants argue they took the regular retirement because it was easier. They didn't have to give any disability paperwork from their doctor to the company, but they still retired because of their allowed conditions. And the commission has found that that is enough to show that they retired due to allowed condition, no voluntary abandonment, and they keep getting temporary total. So again, I just want to bring up that a quit is a voluntary abandonment and will cut off temporary total. So you want to show that you want to think of retirement as a quit, as long as the quit is not due to the allowed conditions in the claim. Another thing you can do if your claimant has retired, even if they can show it was due to the allowed conditions and they're given temporary total, you can always, as long as you don't have a problem with your union, you can always offer them another job within the restrictions, see if you can get them back to work, and if they refuse that, use that as a basis to terminate temporary total. This retirement issue comes up most often with long-term illnesses like asbestos or silicosis, but also with things like back injuries. A lot of times those are long-term, or shoulder. Okay, I promised I said on vocational rehabilitation. Yeah, so we have plenty of time for that. Okay, vocational rehabilitation. Process of restoring the vocational functioning of an Ohio worker with a workers' compensation claim. So the reason why I bring this up with temporary total is I said earlier, once the claimant has reached maximum medical improvement, they're at a treatment plateau where they won't get any better, or there's no reasonable expectation of them improving, they're no longer entitled to temporary total. It doesn't mean that they can automatically come back to work. It doesn't mean they're cured. It just means they're no longer entitled to temporary total. They could be entitled to other benefits. And one of the benefits is living maintenance while going through a vocational rehab program. Living maintenance, it's in another slide, but it's the payment they receive while going through vocational rehabilitation, or voc rehab. Voc rehab is meant to rehabilitate an injured worker who can no longer return to their former position of employment, to train them to do something else so they can get back to work even if it's not at their old position. It's voluntary. You cannot force a claimant to go through voc rehab. They have to want to do it. They have to meet 3 criteria for eligibility. First one's pretty simple. They have to have an allowed claim. The second is less complicated than it sounds. They have to have a significant impediment to employment or maintenance of employment as a direct result of the allowed condition. It sounds complicated, but this is always granted. The commission always finds that they have a significant impediment. They don't even really need a doctor to say they have a significant impediment. It's kind of taken for granted. The third requirement is they have to have one of these things. And the way most claimants will get in is the third one, they've received a permanent partial award and they have restrictions within the last 6 months. So everybody gets a permanent partial award. If you're not familiar with those, it's a damage award. It says that they're permanently impaired a certain percentage and they get money for that. We'll talk about that a little more in the first webinar. But if they receive that award and have restrictions, they'll be eligible for voc rehab. The other one we see a lot is the maximum medical improvement determination and job restrictions. You have to have job restrictions in order to go into voc rehab. If you don't have job restrictions, then you can return to your former position and there's no need for voc rehab. So that's kind of a given. And most claimants have either reached MMI or received a permanent partial disability award. Sometimes they won't be eligible on technicality because of one of these things, but most claimants who ask for voc rehab are eligible. You can't be working on the date of a referral to voc rehab program, which should be obvious. If the claimant is working a job, they don't need to voc rehab. They're already working. And the first step in the process is the claimant has an assessment to determine eligibility or feasibility. This is done by a vocational expert who will assess the claimant to decide whether they're even feasible for returning to work. And sometimes they're not feasible, and that's the end. So feasible means there's a reasonable probability the injured worker will benefit from services and to return to work as a result. Sometimes they find that they're just untrainable or too injured to do any work. It's determined at the time of the referral and is assessed throughout the rehabilitation process. So just to go back a little bit about the mechanics of this, claimant will request vocational rehabilitation from a self-insured employer who will either say yes or no, or from the bureau who will either say yes or no. If the bureau or the employer says no, you can have a hearing on whether they're eligible. And if the commission finds they're eligible, then they're sent to a feasibility assessment. So the goals of vocational rehabilitation are in this order. The goal is to return them to their original job. If that doesn't work, to return them to the employer a modified job. If that doesn't work, to return them to a job in the same industry, not necessarily at the original employer. And if all else fails, to get them any job. I touched on living maintenance. Living maintenance is paid by the self-insured employer, or it can be paid by the bureau from the surplus fund. This is it's temporary total. It's the same amount, but it's packaged as living maintenance. The only thing you need to do to be eligible for living maintenance is to be doing a voc rehab plan. It's not payable until they start the plan. So I said they go to the assessment. The assessor decides if they're feasible. If they're feasible, they come up with a plan. They both sign it. And the day they start the plan is when they start getting living maintenance payments. Payable at the same rate as temporary total. The thing you need to know about this slide is really that if you're state funded, it will still affect your rates even though it comes from the surplus fund. So claimants in a voc rehab program, they're receiving living maintenance. That's going to be terminated if they find a job and return to work, just like temporary total, or when the plan's closed. So whenever they stop doing everything in the plan, which I'll talk about in a minute here, they can get up to 6 months of living maintenance. So it's different than temporary total. Temporary total can be ongoing forever. Living maintenance, you can only get 6 months, unless the commission determines they benefit from more, which I have actually never seen. So the claimant can get an extension after 6 months of living maintenance. They can ask the commission for more because they're continuing the program. In theory, the claimant could be in school or something like that. I just have never seen that happen. There is an offset, so if they're receiving any other wages, they shouldn't get the full living maintenance payment. Self-insured employers have to provide voc rehab equal to or greater than the services provided by the bureau, just like everything else. So what's included in the plan? What is voc rehab? Well, this is what we see most often. Career counseling. Someone helps the claimant put together a resume and a cover letter, helps them with a job search and any training they might need. Usually it's pretty basic. There could also be work hardening or job modification services. Reconditioning through physical and occupational therapy. Don't see this often, but according to the rule, there could be pain and stress management, nutritional counseling, and psychological services. This is in the rule as well, but I've also never seen this. There could be relocation expenses if job opportunities don't exist within a reasonable commute on a daily basis. And the claimant has secured a new job somewhere else. They can get relocation expenses up to $2,000 and might get temporary housing for 60 days. But generally, it's a service where the claimant learns how to make a resume and somebody goes through with them and helps them to find a job within the restrictions. And it's a way to continue receiving living maintenance. And then even after their job training, they can get something called wage loss compensation, where they're done with their temporary total, they're done with their living maintenance, but they're looking for a job, they can get wage loss compensation, which replaces the wages that they're not receiving due to the allowed conditions in the claim. And the difference between wage loss and temporary total is they're not eligible for temporary total because they're at maximum medical improvement. That's the subject of another webinar. So that is all the slides. I think we're at time Well, no, we got 5 minutes if anybody has any questions.